So welcome to Ethics, Adjudication, and Child Custody, and we like to call this a subtitle of Managing Anxiety Through Knowledge. I'm Lindsay Childress-Beatty. I'm the Deputy Director and Director of Adjudication in the APA Ethics Office, and I'm very honored to be here with a quite esteemed panel. They are all former members of the APA chairs of the Ethics Office, or one who's a future APA Ethics Committee Chair.
I'm Dr. James Bowe. I'm in independent practice at this point in time at University Psychiatric Center, which is affiliated with Wayne State University. Used to be Director of Psychology at Hawthorne Center for many years. I've done quite a bit of publishing in the child custody area, so you might know me through that avenue.
And you're the incoming chair, incoming chair of the Ethics Committee. I'm Robin Deutsch, and I am currently the director of the Center of Excellence for Children, Families, and the Law at the Massachusetts School of Professional Psychology, and recently, formerly, for 20-some years, the Director of Forensic Services at the Children in the Law program at Mass General Hospital and Harvard Medical School. And I was the chair of the AP Ethics Committee either in 06 or 08, I don't really know.
I'm Dr. Nancy Magera. I'm in private practice in Atlanta, Georgia. I do child custody evaluations and child therapy and general child-adolescent practice. I've been there a long time, and I was on the APA Ethics Committee and chair. Jim actually followed me on the Ethics Committee as the person that worked on child custody. We have niches in the Ethics Committee, and there's usually somebody who kind of fills that niche that works on child custody expertise, and he followed me. That was my experience on the Ethics Committee.
Just add one more thing, that I'm a former president of AFCC, and we are really thrilled to be integrating as much as possible from APA into what we're doing here at AFCC.
Okay, so I want to take a moment for a few disclaimers. Obviously, only the APA Ethics Committee can definitively interpret the Ethics Code. The comment of the presenters are their own. Any vignettes discussed are not individual ethics matters referred to the Ethics Office. I like to think of this like the disclaimer that's at the front of a fiction book. Any resemblance to individuals living or dead is purely coincidental. And also, please don't bring up in detail any of your ethics issues if anyone in the room happens to have any. You can talk about issues you come across, but not any ethics cases or complaints or anything like that. Okay, so here are our learning objectives, and we'd like to start off talking about giving you a little bit of information about licensing board complaints and the APA ethics process.
I'm going to briefly go over some research I did over the last, well, now it's about 12 years. The first day was with Fran Quinnell, who was an intern of mine at the time, and she's currently at Northern Michigan on the faculty there. But we surveyed child custody evaluators. They were all psychologists. They came from 33 states. And we threw in this question really at the very end of the survey, and because nothing had really been asked regarding this whole issue about board and ethics complaints. And we were very surprised when the survey came back. We analyzed the data. 35% of evaluators said they had a complaint, either a board or an ethics complaint, which is a high percentage. It's basically 1/3. David Martindale and I did a follow-up study in 2009 that was published as well. We found that 22% of psychologists performing child custody evaluations had experienced an ethics complaint, and that ranged from 1 to 12 in terms of the number of complaints. On top of that, we did look at board complaints, and it had climbed to 51%. So half of the evaluators acknowledged having a board complaint. Now, in terms of the outcome, because you always want to ask about that as well, of the 22 psychologists that reported an ethics complaint, only a small percentage, it ended up being 1.7%, reported an unfavorable outcome. So even though you might get a complaint, the chances of anything happening are quite small. And we found the same basically for licensing board complaints, that nobody lost their license because of child custody work per se. There might have been other issues, but it wasn't because of child custody. So Lindsay's going to go over some of the data that's been collected through the ethics office to kind of reinforce this, that even though it's a high-risk profession, in the end, the outcomes are generally not unfavorable. So she'll continue.
Okay, so just to give you a very brief overview of the ethics office process, ethics office cases come to the ethics committee via 3 different routes. It could be a show cause case, and this is when there's been a serious action against someone's license by a licensing board. We do have a complaint process where members of the public or other psychologists can complain and file a complaint with us. And then there's a sua sponte process where the ethics committee, when it finds out about something, can act on its own accord. Our staff is well versed in ethics cases, the numerous years in working in the ethics office, and I'd like to introduce and embarrass Pat Dixon, who's over in the corner trying to hunch down. And she is one of our 2 investigators in the ethics office. And it says here 20+ years, Pat, but it's been 25. So we'll stay with 2 decades experience. We also have Stephanie Brassfield, and she's been there over 17 years. She couldn't, unfortunately, be with us today. And then, of course, I'm the deputy director, and then we have our director, Stephen Benke. And we always remember in the ethics office that the American Psychological Association is a membership organization. We're not a licensing board. We don't take actions against a license. Members determine the rules and procedures to follow and decide on any violations or sanctions. And if you know anything about APA ethics, you know that the rules and procedures of APA provide a lot of process. It's not a rubber stamping of the licensing board. Psychologists, if there is a serious licensing board action, are given an opportunity to show cause why they should not be expelled from APA. So it's not an automatic process. And there's multiple layers of membership review. All cases that are opened are reviewed by the ethics committee, and then there's a whole built-in system of appeals, so multiple groups will hear it within APA. Also, we would like to highlight that there are some educative aspects of the process. I know sometimes it doesn't feel like this if a psychologist is going through the process. But through our questioning, if we open a preliminary investigation of a complaint, through the questioning, the psychologist can sort of see the issues that we're working on and that we're thinking about and can respond to them. The ethics committee also does educative letters. They may issue directives, and they give a rationale whenever they make any recommendation of a sanction. So let's talk about the statistics for a minute. Our experience is the vast majority of psychologists are competent and ethical, and I really think that these numbers, this is borne out in the numbers. So 0.07% have had a complaint filed against them in 2010, and 0.08% we received notices from state licensing boards of these serious actions. In terms of ethics cases, 20 members had cases opened, and 18 members left the association. And it's interesting that 18 is very similar to the numbers you can see in this chart. So there's multiple ways that you might end up leaving the association. You might have a stipulated resignation. You might be expelled. There's automatic expulsion for those who don't respond to one of our show cause notices. And then you also have an ability to opt out of the process. If it gets to a certain point, you'll be given an opportunity to resign under ethics investigation rather than go through the process. But you can see that the numbers that 18 is not unusual, that's about the number that leave the association through the ethics process. The relationship between the APA ethics code and APA guidelines. As you know, the APA has child custody guidelines for family law, just as the AFCC does. The APA ethics process has a section that is aspirational principles, and those are not enforceable. And then it has a section that are enforceable standards. And these are the standards that are involved when a case is brought against someone. Guidelines from APA, on the other hand, are completely aspirational and are not enforceable. However, along with lots of other sources, the APA Ethics Committee will consider guidelines when they're trying to determine the aspects of a case, but that's not dispositive. All right, so I'd like to ask the panelists to talk for a minute about the most difficult ethical dilemma that you yourself have encountered.
Well, I can think of two right offhand. One is I get a lot of referrals of course, from the legal community, but some of those people are also being evaluated in one capacity or another. So I've done a number of evaluations on attorneys and then also judges. Run into a problem if you're going to get cases from these people, and basically you have to avoid them. I mean, that has to be some understanding right up front. But, you know, when you're doing an evaluation on a judge, you can't always control if you're going to be testifying in his or her, you know, courtroom. So that can be quite tricky, especially if it's a judge that's like in the family division, because most states have, you know, the criminal division, the civil, and then the family. So it can be an issue. Another one that I've run into, and I don't know how many of you have experienced it, but you'll do the child custody evaluation, and then later you hear that one of the parties is involved in a lawsuit that's separate from this. I had one, a man had been basically dismissed from his employment, and he was suing over that. And next thing I know, I get a subpoena to be deposed as a witness in this case. And that creates a real conflict, because I originally did the child custody evaluation for the family court. I didn't do it for the civil court, and as all of you probably know, that you can't really apply test results in different settings. One, you're going to, child custody setting, people are going to look very defensive. Personal injury, it's going to be the opposite. They're going to be kind of over-acknowledging their difficulties. So in that case, what I did is basically called my malpractice company, which was American Professional Agency, talked to their legal department, which is the thing to do. Keep that in mind. You can always consult with your malpractice company. You can call the ethics committee, consult with them as well, and got pretty good advice from them. What they basically told me was I have to get a court order. You can't go on a subpoena. It would have to be a court order to be able to testify. So I got that, and then they did the deposition. It lasted really a couple of hours, and after I explained response style issues and everything, they kind of realized that I didn't have much to offer. I think the one thing you always have to think of is ahead. I view child custody as like a minefield, and you just have to be very, very careful, and you have to think ahead at all times. And we'll stress that throughout this presentation today.
So, Robin and Nancy, do you all have any ethical dilemmas that you've run across?
Oh, always. I'm also thinking of two. One of mine was I was doing a child custody evaluation. I was in the middle of it, at least in the middle of it, and I then discovered that the father was dating a former therapy patient of mine. A second case, I had a case where I finished the child custody evaluation, and then it did go to trial, and the mother changed attorneys. And she changed attorneys to an attorney who I had evaluated as part of his child custody evaluation. So that would have been considered, it could have been considered a conflict and a dual role, but the evaluation was completed at that time. If I had started the evaluation and that was the attorney, I never would have taken it. But this was at the end of the evaluation.
So Nancy, how about you? How about some of the ethical dilemmas you've run across in your practice?
There are so many. Where to start? I can think of two right away. One, and these are both kind of old ones. I was in the middle probably the middle of a custody evaluation with a quite litigious-seeming father, and I had to make a mandated child abuse report about him in the middle of the case for physical abuse. And I made the report. He knew I was making the report. And I decided that I wasn't sure I could continue and finish this evaluation because, I felt like if it didn't come out the way he wanted, he would then accuse me of bias because I would have already in the middle have decided he was a child abuser. And so I asked the two attorneys, my memory is I asked the two attorneys if we could have a meeting with the judge. And in any case, we did have a meeting. I remember meeting in chambers with the judge, who I had a good relationship with, and the two attorneys, and I think I had a good relationship with both attorneys. Anyway, the attorneys and I and the judge met, and I said I would only continue with that evaluation if everyone was 100% in agreement that I could continue, and everyone agreed that they believed that I could be unbiased, and everyone agreed. but I kind of wanted that like really up front. I finished the evaluation. It wasn't favorable to Dad, and at least at this point, he never filed anything. It's probably been at least 10 years, so it seemed to work out okay. But it was a really difficult dilemma at the time because I could see his point if he felt that I was biased after reporting him. The other case was, I think, a little trickier because I was doing an evaluation on a modification of child custody, and everybody was remarried, and the ex-wife had some really very, very serious allegations about her ex-husband, and she didn't have very good ways of verifying that. He had a current wife, and when she came in to meet with me for her collateral interviews, she, on about her second interview with me, told me that she was very, very fearful to tell me this, but basically everything the ex-wife told me was true. And she didn't want her current husband to know that she told me this. So what to do with that information, how to put that in the report, how to use that. And she was very sincere in her way she verified that. Had to do with abuse and control and things like that. So I actually don't remember what I did with all that. I probably got a lot of consultation about it, but it was a long time ago. But it was one of those horrible moments where you think you know what someone's going to tell you because it was a current wife, and it ended up being a very, very different conversation than what you thought she was going to say. And that happens every so often when you call a collateral and it's someone that a party gives you that's a family member usually. That's when I'm most surprised. And you think they're going to be one of those typical rubber stamps that says this is a great parent, you know, I'm the parent, I'm the sister, I'm the brother, and it ends up saying I have serious concerns about this person.
So the question is basically, if you're given this information, given that anyone seeing you has been given informed consent that this is not confidential, you can't just sit on that information. You have to act. Before we do that, I'd like to talk for a second about how the APA Ethics Office responds when we get a consultation call, and that's a roadmap that I suggest that you also could use when you come across your own ethical dilemmas. So when someone calls into the APA Ethics Office, we help them tease out what part of this question has an ethical aspect to it, what part is involved with the law in your state or a federal law. What about the clinical? How do you manage this clinically? How do you interpret what's happening clinically? And then take a look at what the impact is going to be from a risk management perspective. So when you actually have a decision to what you're going to do to your dilemma, you've looked at it from these four aspects, and you feel comfortable that the decision you've made fits in with all these four aspects and that you've considered these four things.
Well, I'm going to start by saying I sleep with the ethics code under my pillow. Actually, I said that once in a panel, an AFCC conference, and when I got back to my room, someone had made me a CD with this on it so that they thought it would be better to sleep with. But, you know, there are really specific ethical principles in here that we rely on that will reinforce exactly what you said. And the first one is 9.01, Bases for Assessment, which says psychologists base the opinions contained in their recommendations, reports, and diagnostic or evaluative statements, including forensic testimony, on information and techniques sufficient to substantiate their findings. The second ethical principle that this really addresses, and I think it's often helpful to think about it, you know, we have both the APA guidelines and we have the AFCC model standards which help us in doing that. But as psychologists, I think whenever there's a question, it's helpful to go to the ethics code, and it will really give us the information typically that we need, or we consult about it. A second one that we maybe could think about is 2.01, which is about the boundaries of competence. And 2.01F says, when assuming forensic roles, psychologists are or become reasonably familiar with the judicial or administrative rules governing their roles. And just to be really clear, in 1.02, where it says conflicts between ethics law, regulations, or other governing legal authority, if psychologists' ethical responsibilities conflict with laws, regulations, or other governing legal authority, like the judge, psychologists clarify the nature of the conflict, make known their commitment to the ethics code, and take reasonable steps to resolve the conflict, etc.
So have you all, I assume then, have run into this kind of an issue probably numerous times.
Right.
How do you handle it?
Well, you know, in Michigan, with the economy as bad as it is, we're getting a lot of referrals just for psychological evaluations. That's it, not the full custody. And you have to stay within the referral question. I think that's the key. Even if you feel there's more there, you can't go down that road because you haven't been ordered to do so. And as Robin mentioned and Lindsay, you know, you only answer the question ethically that you have been set out to answer, and you don't go beyond the data. I mean, that's the most important thing. When you start making statements about the other party, and we see this a lot as well, it's a one-sided eval, meaning one person's being evaluated, and then they start making comments about the other party. That's dangerous territory to get into.
So adding the appropriate limits and expressing what you've done, what you've not done, and then based on what you've done, what you can say and what you can't say, and what's missing from what you're able to say.
I mean, mental health is usually one issue in the best interest of the child. I mean, in Michigan, we've got 12 factors. Mental health is one of them, but there's many other factors that when you do a child custody case, of course, you're going to address those factors. In this type of evaluation, you're basically looking at mental health, and that's it.
So what kind of comments do you say back to the judge if the judge is really pushing you or an attorney is really pushing you? I mean, do you pull out your ethics code?
I was just going to say, I think in what I see a lot, regardless of what you're there for, whether you're the child's therapist or whether I'm the custody evaluator, like once you're there, especially if the judge respects you, the judge and the attorneys, it's kind of like somebody has paid for you to be there and they want to get everything out of you they can. So they may ask you nutrition questions, they may ask you medical questions you can't answer, they may push you, you know, like this example. And so I bring up the code all the time. It's whether it's competence, you know, you can't answer these questions. It's like, I'm sorry, that's a medical question. I'm sorry, that's a whatever question. You know, and so I use it all the time to explain that. And I know they'll say things, yes, but you're the one that's here. Don't you run into this all the time? Don't you know about this? Well, I might know something about pharmacy, but I'm not a pharmacist. I may know something about whatever it is. And, you know, so I think that's what we get caught with. We're the one there, and they try to get it out of us. And we have to, it's our job to educate them. And I know when I was on the ethics committee, we had people in their defense would say, well, but the judge asked me, and I thought I had to answer it. And, you know, and it's like, but it's our job to educate, because it's our ethics code.
And I guess there's a balancing there, too, of what do you need, what research do you need to be looking at when you're doing the evaluation versus what is going beyond your area of competence, like into pharmacy or into nutrition. Or so where did the data go? Dr. Smith has done child custody work for many years. He considers himself a seasoned evaluator with a good reputation. His policy is to take notes during interviews via computer. He's excellent at word processing, and this method seems to help in rapidly gathering information. He then saves the files for further reference. So regarding taking notes via the computer, do you all think this is a good practice?
I mean, one of the reasons we ask this basically is because often attorneys will ask for our files, and they might even go through and say, well, maybe you doctored this a little bit. So the question is, you know, if you're into technology, is it possible in that domain as well? But there are ways of securing the file and dating it even. But it's something that people have to think ahead, and that's one of the reasons we're using this vignette, is that this is becoming more and more popular now for people to take notes during their sessions on computers. I personally don't do it, but I know a number of people who do. But you have to think ahead. What are the pros and what are the cons? And not everybody is technologically, you know, savvy as others, and that's one of the ethical issues in here as well, is the competency at using technology. Yeah, but you could print it out after the fact. I mean, I could alter the file, print it out, and then have a hard file and say, well, this is, well, I don't want to go on and on about this, but, you know, it basically comes down to, in some way you have to document that that's the original.
All right, let's go on to another vignette. The world of social media up in smoke. Dr. Jones is internet savvy, and he has had a personal Facebook page for several years. As a way of attracting additional business, he decides he will expand his presence on the internet by developing a website. He includes testimonials from his clinical patients. In order to connect with attorneys and mental health professionals, he also joins LinkedIn, a large professional network on the internet. He receives a number of referrals over the next couple of months. So what potential concerns? So you're worried about the confidentiality of the patients that are now giving testimonials? Mm-hmm.
In testimonials, they're 5.05 in the ethics code. Basically says that psychologists do not solicit testimonials from current therapy patients, as you mentioned, partly because it's going to make an association between that individual and the therapist. So
it's also a real balance power thing, because you will have sometimes patients ask you if they can, because they're real excited about that, and it's up to us to talk about how, we have this thing about testimonials, and so sometimes you'll have people that don't really understand that we have this part of the ethics code.
And we get that sometimes in the calls coming to the ethics office, both with things like testimonials from former patients or also with the social media, that you end up as a psychologist having to educate the patients on what the risks to them are of doing, if they were doing something like a testimonial, or if they're using certain modes of communication with you, because often you're more up to speed on it than they are, and they haven't really thought through. So former patients 10 years ago, they want to do a video on how this helped the child with ADHD or something like that, and they're not seeing the possible fact that 15 years down the road, the child might not be so happy to have this video of them discussing their ADHD, and kind of realizing that.
It comes up a lot in media work too, where this is totally off topic, but reporters will always ask you to, this story would be so much better if you would get one of your patients to be in the story with you. And sometimes they want to. And
that's it. When they're part of the driving force behind it, but they haven't really thought through the consequences long term.
Right.
And you have to help, ethically, you have to help them as the psychologist. So let's go on to the next little bit. One of his first child custody cases involves John and Jane Doe and their two children, age 8 and 6. He utilizes interviews with the parents, psychological testing, parent-child observation, and collateral contacts. He does not interview the children, stating they are too young. During the interview with Mrs. Doe, she complains that her husband used marijuana daily. Mr. Doe admitted to some use, but claimed it is for medical reasons, neck pain. Mrs. Doe further expressed concern about her husband smoking it in front of the children, as well as transporting them after smoking. Dr. Jones considers this information, but does not think it outweighs the mother's poor parenting skills. Therefore, Dr. Jones recommends that custody be given to the father. What procedural concerns do you have at this point?
So this falls under competence. Are you competent to do a child custody evaluation, for one thing, because we know part of what all of the guidelines say is that you have to look at the children, and if you're not competent, if you don't think children that age can be interviewed, do you have the competency to do child custody evaluations? It also fits into 9.01, what we had before up there, basis of
I already just moved it.
Of assessment, because is he really looking? Is this a he? Is he really looking at? Is Dr. Jones really looking at everything Dr. Jones needs to look at? Is he looking at the research that goes with that? And we don't know. We're getting to this even more, but do we know? Is there a bias going on with his own marijuana use? So.
And trying to figure out how the marijuana affects his parenting and what the risks are to the children. She's pointed out a couple of them, but are they really occurring, and how do you weigh that risk? And I think, Jim, you said you've come across that in Michigan.
Michigan is the same thing, and you have to have a medical condition to get the medical marijuana card. So I go through all the medical information. They tell me I have no medical issues whatsoever. So then we get to the substance abuse section. They say, well, I have a medical marijuana card. And I said, well, what reason do you have it? Oh, I have stress, or I have back pain, or something like this. But, so then I asked for the original paperwork, of course, that they, turned into the state. But it does become an issue, because if they're smoking marijuana and they're transporting kids and they're interacting with them, it could be an issue. But again, they try to argue that it's legal.
So you're not just looking at that they do.
Yeah.
Yeah.
That's true too.
Yeah. So you're not just looking at the fact that they're using it or the fact that they're having a drink, but it's what they're doing in front of the children, what they're doing with the children in terms of transporting.
Well, and always it's a matter of how does it compromise parenting. So if it's not affecting driving, it's not compromising driving. If it's not, I mean, that's the nexus, is whether it's any kind of substance abuse or use, how does it affect parenting?
Right. So whether it's bourbon or prescription painkillers, maybe even used for a legitimate purpose, and medical marijuana for legitimate or not legitimate purpose. All is how it affects parenting. And I'm assuming that what if it's illegal in that state? Then you've got a whole different set of additional concerns you've got to think about.
I wanted to make a comment about the LinkedIn and the Facebook. I think that those are really different. I think if he is friends with, if the custody evaluator is friends on LinkedIn, they're not friends, if they're connected on LinkedIn with attorneys, I think that's very different than him being friends on Facebook with relatives of one of the people being evaluated. I think being friends on Facebook with close relatives of the person you're evaluating is a definite conflict of interest. I think you're in trouble right away on 3.06, conflict of interest. To me, that's very different than being friends on LinkedIn or connected on LinkedIn with an attorney. Unless that's the only attorney that you're connected with, then maybe that's odd. But if you're connected with a lot of attorneys in a lot of metropolitan areas, there are many psychologists and attorneys that are linked together.
Now, the other thing I'd like to mention is sometimes people think when they post, like on the child custody listserv that some of you might be on, that this is a private listserv and nobody will ever find out what I posted. Think again. Right. People will have access to that, and I've heard stories about, colleagues being on the witness stand being presented with some of their postings. So be very careful what you post on the internet. It could come back to bite you. So.
I think one other comment I'd like to make on what Nancy was saying about distinguishing between various connections. When people call into the ethics office, we point out to them not all multiple relationships are unethical. They're not per se unethical just because you have a dual role. You need to think about the area of psychology you're working in. So you all have a heightened issue to think about because there's apparent conflicts as well as actual conflicts. But the ethics code gives you a standard to think about. And here's the test. Could it reasonably, meaning by other folks, not by you, be expected to impair your objectivity, competence, or effectiveness? And a lot of times that's where, if it's an apparent conflict, it could hurt you because you're less effective if you're seen to have bias. And here's the test. So you can always go back to that test and think through when you're looking at these, and it helps you organize how you're thinking through this connection that you have in a particular case.
And that test is also in both 3.05 and 3.06.
Virtually same wording. 3.06 kicks in more when you already have a relationship and you're thinking about taking another one. All right. So one other question that comes up here that I'd like to ask the panel is, it talks about, so he's called to testify by one side. So I'm wondering, do you vary how you prepare for testifying when you're called by one side? Or is it the same no matter who's calling you to testify as the child custody evaluator? Do any of you have any thoughts on that?
Well, it doesn't really depend on who calls you. In the end, you have to be neutral, you have to be objective, and you have to present the data that you collected. Doesn't matter who pays you, doesn't matter, who subpoenaed you. You still have to take that neutral stance. I mean, that's critical. In terms of getting prepped before going to court, I know this has been a hot issue on the listserv lately. I don't meet with either attorney. I know some people do, but I feel once you start meeting with either attorney to be prepped for your testimony, you're not seen as neutral and objective anymore. And I think you have to be very careful. But and each person has to weigh the pros and cons in that regard. But keep in mind that there are issues that could come up in cross-examination.
I think you also need to be very aware of the statute in your state. So if you're appointed under statute by the court to be the custody evaluator, you are the court's client. And if that's the case, then I think it's a mistake to be prepped by either attorney or to talk to either attorney. Now, there's some states where that's not true, where you're hired, a custody evaluator is not appointed by the court, but is hired privately. And I think that puts everything legally in a different light. But from a standard of practice point of view, I think what Jim said is your job is to be to remain as neutral as possible. It doesn't matter who calls you, who pays you. Once you start being prepped or talk to one of the attorneys, you've lost that stance.
Okay, let's go on to the next vignette. Juggling numerous roles. Dr. Money has been doing child custody work for many years. He's well versed in the field, but stressed by the work. He decides to expand his practice by providing consultation services to attorneys. He figures that such work would be less stressful. I'm not sure about that, but we'll see. He sends out announcements to local attorneys describing his consultation services, which includes work product reviews of child custody cases. Dr. Money is immediately contacted by Attorney Bell, who requests the service. Dr. Money starts reviewing the case. Within a week, he also receives a court order to conduct a child custody evaluation on another of Attorney Bell's clients. Dr. Money is troubled by this situation, but figures they are different roles. Also, he feels he will be able to maintain his objectivity. Dr. Money completes the work product review. Attorney Bell is very happy with the findings and requests that Dr. Money testify at the upcoming trial. Around the same time, Dr. Money is completing the court-ordered child custody case. He receives subpoenas for both cases, with both hearings occurring before the same judge, only days apart. So I'm not sure he's relieved himself of all stress by taking on this new work. What do you think? So does anybody have any comments on how they would think about these issues? Okay.
Total silence. How many do work product reviews? Anybody do them? Work product reviews, meaning that attorney contacts you, wants you to review somebody else's evaluation, critique it in terms of the good and the bad.
The ugly.
So a few of you do, but not as many. Not as many. So
How
have
do you
you
handle this issue if the same attorney is referring cases to you?
Have you run into this?
I'm often asked, because I'm an expert in domestic violence,
Okay.
I'm often asked to look over the law guardian, look over all the evidence
Okay.
that's entered in on behalf of the child.
Okay, so your role is a little different in that it's being directed by the GAL pretty much.
So in this case, when you get to the part where within a week he receives a court order to conduct a child custody evaluation on another of Attorney Bell's clients, what would you do? Really?
She's trying to lower her stress, after all.
So that is a really important point you just made. You never do two things at once with any attorney because it can lead to a conflict of interest. It can lead to an appearance of partiality or bias, right? Playing two different roles with one attorney. This scenario is about two different roles. So yeah, you can have 4 custody evaluations with the same attorney, and in some communities there aren't that many attorneys to go around anyway. But this is playing two different roles with the same attorney. So you've agreed to be one attorney's expert, consultant, and then you get a custody evaluation order with that attorney representing one of the clients. So there are two different roles that we're...
I think one reason it might be a problem is that issue about could it possibly or reasonably affect your effectiveness? Because it might look like you're not objective because you have just done a job for an attorney. And the other attorney could certainly question you about, are you going to be totally impartial in this child custody case because you have just worked for that attorney as his witness at the same time. And so you may be thinking you're totally objective in this child custody case, but if it reasonably could make it look to someone else like the court that you're not impartial. I think that's where that problem would come.
And 3.05a says a multiple relationship occurs when a psychologist is in a professional role with a person and at the same time is in another role with the same person. So while they're both professional roles, one is as a consultant, a one-sided consultant, and the other is a child custody evaluator.
Remember, you have to have professional malpractice liability insurance. Okay, we did a study in which we found 35% of the people did not have coverage, and they were doing child custody work, which just does not make sense. You're in a high-risk field. Now, the chance of you actually being sued in terms of malpractice, if you're court-appointed, is pretty small. But it's the board complaints that are going to be more frequent. And most malpractice insurance companies will cover you up to about $5,000, which is not a lot of coverage when you're talking about legal fees. So they have additional riders for $25,000, $50,000, $75,000. It's only an extra $50 to $75 a year. I would get the maximum rider, which for most policies is $75,000. In Michigan, the average board complaint costs about, if it goes all the way, is about $22,000. So this is not cheap. And so you want to think ahead in terms of getting that board coverage. Constantly seek out consultation, okay? And this is a high-stress field. You can call the ethics office. You can call, as I mentioned earlier, your professional malpractice liability company. Talk to them. They have attorneys on hand that will walk you through it and give you advice. And they'll document that was done, so if there's any issues down the road, you can point out that, I did seek consultation. You might have colleagues that you work with as well. I would seek them out, and they talk a lot about that in the ethics code as well. Avoid highly litigious cases. And sometimes we don't know how litigious it is until we get into it, but you get a feel for it after a while, especially from particular attorneys. Perform only court-ordered evaluations in which you are appointed by name. Okay, I think David Martindale stressed that yesterday as well. And use sound risk management principles such as maintain appropriate professional boundaries, avoid multiple relationships. I have that right in my statement of understanding that I've had no prior contact with this individual in any capacity, social, professional, therapeutic, anything like that. So everybody signed off on that right from the beginning. Used in an informed consent or statement of understanding. This is very, very important. It's best almost if it's part of the court order, but the court order can get pretty long if you throw this in as well. So I always send it out ahead of time, have the litigants review it. When they come in for the first session again, I review it in detail. I go into great detail how this forensic evaluation, meaning a child custody case, is different than a therapeutic relationship. A lot of these people have been in therapy before, and they expect it to be very similar, and it's very, very different, as we know. So you want to point out that you're there to scrutinize what they say. You're there to be neutral, objective. You're not there to be their advocate. You're not there to give them support and guidance or give them advice as you go through the evaluation process. But that's different than their therapist, so you want to make that very clear from the beginning. But in terms of that statement of understanding, I also, in one of the vignettes, touches on this, is the social media world, which has become a big one. If you're going to do internet searches on people, you better have it in your informed consent that you're doing so, okay, that they have an understanding of that. And it just takes a sentence or two in there, and I've never had anybody object to it. But in this world of social media today, there's a lot out there on the internet. So you just want to cover yourself in that regard. Clearly identify financial arrangements. This can become a huge issue. And as we know, sometimes these evaluations appear, just straightforward in the beginning, and then a lot of issues get presented to us over time, and they become much more complex. You want your financial arrangements spelled out from the beginning. Okay, what's your fees going to be, not just in terms of the evaluation, but post-evaluation if you're asked to testify in court. Utilize standard evaluation procedures, and I'm sure everybody here does, but it's surprising when you do work product reviews of, we gave a vignette today of if they didn't interview the kids, saying, the two children were too young. I don't think 6 and 8 are too young to be interviewed. Or not doing, parent-child observations. That really needs to be part of the protocol. And then keep all your records. Don't lose them. Don't discard them. Everything has to be kept. Closely adhere to your ethical standards. We have them for APA, the social work standards, ethical standards as well, standards for licensed professional counselors. There's also the child custody guidelines for APA and AFCC, and keep up on the research. Treat all litigants in a fair, honest, and transparent manner, and this is critical. If in these cases they're stressful, we all know, and litigants can push our buttons, but it's important to try to stay as honest and fair as you can. Present the information as you see it. Report information in an objective manner. In the studies I've done, study after study indicates people are upset when they feel when you're biased. Now, bias in your eyes may be different than bias in my eyes. Attorney often figures, well, you didn't support my client, so you're biased. But, try to present both sides of the case. I think that's a critical thing, and test hypotheses.
So, Nancy, what's the best risk management strategy that you've picked up in your years of working in the field?
Well, Jim already said all of them, but because we all say consult is our number one thing. We consult all the time. But the only additional thing I could think of, it was mentioned in the plenary today, but I've actually been in a consultation group in Atlanta of child custody evaluators for probably 20 years. We meet once a month.